Good morning, everybody. I hope y'all are doing well. We'll give a little bit of time for everybody to hop on before we get going. Another attorney exciting topic for you to listen to today. I think most of Texas is pretty cold. Houston may be a little bit warmer, but everywhere else, I'm feeling the chill. It'll make for an exciting Halloween weekend, whatever you are going to be doing safely, right? Following all of the COVID recommendations and requirements. But we have definitely gotten our cold snap for the season. Today, we're going to be talking about kind of board transition from developer controlled to owner controlled communities, and just kind of a lot of the nuances between some terminology used there, some other provisions to think about. And a lot of these provisions are going to be applying to community associations, even if they are 100% owner controlled. So let's see how we're doing on time. Give it another couple seconds. All right, well, let's get going. As you may or may not know, my name is Clint Brown. I'm with the law firm Roberts, Markel, Weinberg, Butler, Haley. And today we're going to be talking about transitioning from kind of a developer or declarant controlled community into a board, or an owner or resident controlled community. So when a developer kind of comes in, he or she buys a big chunk of dirt or multiple parcels of dirt and begins working on the plats, his or her plats. And it really kind of depends on whether or not the dirt that the developer wants to develop is located in a county, or whether it is located within city limits or an ETJ of a city. If you're within city limits or the ETJ, there are some additional requirements as it relates to developing in that area that you've got to comply with. Many times there is something that is called a development agreement that you have to enter into, where there's some give and some take. The city wants you to do X, Y, and Z. They give you A, B, and C. Everybody's happy. That development agreement has a lot of requirements that the developer has to comply with in putting the community together. If you're not kind of in there and you're out in the county, it's a lot easier to basically build the community. And so, the developer just has to make a decision as to what he or she wants to do. Now, what they do when they come in and they buy up all this land, they basically have the capital P property, and then they may subject the capital P property, just reference it in the first declaration, and then indicate that as time progresses, they can add pieces of this capital P property via a phase or a section and make it subject to and bound by the declaration as they develop, right? Because they don't develop the entire 1,500 lots right then and there, right? The plats get filed year after year after year. So they're selling in one phase and section. They may want to start developing that second phase that doesn't have any infrastructure yet. And they do it that way. As you know from previous presentations by myself or another attorney with our law firm, when you look at the plat and you zoom in about 200% or so, you'll see surveyor notes. And within those surveyor notes, you will notice that there are certain deed restrictions on the plat as well regarding easements, setbacks, what you can and cannot build on the property. There may be some reference to impervious coverage limits, all things to think about when you're looking at those plats. But that's what the developer does. So they come in, they develop this declaration, these governing documents, they develop the streets, the lights, the utilities, the sewage, and all of that with an idea that they want to maintain control, because their main purpose is to get in there, build a community, sell the homes, sell the lots. And how do you do that? You do that by maintaining or improving the fair market value of the properties. Well, how do you do that, right? You want the community to look nice, be aesthetically pleasing when a prospective purchaser comes in, and that's where the control idea kind of comes from. They want to have control until they're done. They want to be done, and then they give control over and they leave and they move on to their next project or projects. Here are the traditional ways in which developers controlled community associations. One was a Class A and Class B membership. And so Class A was one type, and it's basically the individual owner, and each owner of a lot gets one vote. So one vote per lot. The other class is the declarant, and that class may have absolute power to control votes, or they may have weighted votes where for every lot they owned, they got 10 votes or 15 votes, with the idea being that when they had their annual meetings, they were able to control who was elected on the board. Why? Because they had 1,500 votes where maybe the other residents only had 300. So the 1,500 votes are always going to win over as it relates to the 300. Another way developers and declarants kind of maintain control was a conversion date. So basically, at this date, or maybe it says the latter of January 1st, 2029, or the date the declarant sells his or her last lot, then it converts over to owner control. And maybe it says the earlier to occur of. I've seen some earlier documents use the earlier of and then those two scenarios. And then finally, just having a declarant control period, just saying, hey, here's the declarant control period. It is the earlier or latter of X, Y, and Z. And once that hits, it converts over to owner control. So that is historically what's happened, but in I believe it was starting around the 2013 legislative session, there was a new definition that was inserted into the Texas Property Code. Next slide. Thank you. And that was the development period. So this defined term came into 209.002. 4 of the Texas Property Code in 2013, and it provides this kind of unique definition, and it's a period stated, so it's got to be stated in a declaration during which a declarant reserves a right to facilitate the development, construction, and marketing of the subdivision, or a right to direct the size, shape, and composition of the subdivision. So there's this new term of art, development period. Why they didn't use declarant control period when a lot of documents were using that terminology rather than development period, who knows? But the legislators did what they did. So what does this mean? First and foremost, we've got to keep in mind that there really is no limit on duration. That means your governing documents are going to be placing that limit. It's not the code. The Texas Property Code doesn't talk about the limits for single family communities or townhouse communities that are governed by Chapter 209. It also makes no reference to the control of the POA for the subdivision. So who's going to be controlling it? Who is this board of directors? Who's going to be making decisions? Well, the definition of development period does not talk about that. So again, we're stuck with looking at our governing documents, at our declaration. And it does not mean the period during which the declarant may appoint persons to serve on the board. They are not one and the same. So development period and then declarant control, when the developer can appoint persons, may not be the same term of art. So keep that in mind when you're looking at your governing documents. So what do? You've got to first look in your declaration and say, is there a development period defined somewhere in the declaration? If so, does it provide for a period of time when development period terminates, or some sort of if this then that, or the later or the earlier of? And then finally, is the development period tied to the control of the POA? So I've got some communities where the control of the POA may transfer over to an owner-controlled board, but the developer retains development period rights and maintains the right to control architectural control committee approval or denial for new construction homes. So the developer's kind of like, hey, the community's pretty much built out. I've only got 50 lots left. I just want to control what's being built on them because I'm also a builder. I have my declarant or developer hat that I wear. I also wear a builder hat. I just want to build these last lots and then get out of Dodge. So they basically allow for that development period to move over, or declarant control period to move over to the owners, but then they still have that development right and building right through wording as it relates to the architectural control committee. So here is a sample provision for the definition of development period. And it's the period during which declarant reserves the right or the authority to facilitate building up the community and marketing it. And it exists for 10 years from the date the declaration is recorded, or so long as declarant or a builder in the business of constructing homes who purchase lots for the purpose of selling completed dwellings owns one lot subject to the provisions of the declaration, comma, whichever period is longer. So those are the two: 10 years from the date the declaration recorded, or as long as a builder or the declarant owns one lot in the entire community, then the development period continues. And then it says, provided that the declarant can decide to terminate earlier if they want to. And if they want to terminate earlier, all they have to do is record a notice of termination of the development period in the real property records. So this is an example of a development period provision. Again, Texas Property Code, that section of 209 gives us really broad authority to define it. So it's incumbent on you as managers or board members, for that matter, to kind of review your documents to figure out what development period means. All right. Now, here is another provision, 209.00591, C as in cat. And this one became effective in 2012. And it says a declaration may provide for a period of declarant control of a POA during which a declarant may appoint and remove directors and officers. So again, we just got done talking about development period. Now we're dealing with a different term of art: declarant control, or declarant control period. And this says that the declaration can provide for that period during which the declarant or the developer gets to appoint and remove board members and officers. Okay, so what is the period of declarant control? Sometimes there is no limit on duration. It is what it is. The developer has declarant control until they no longer want it. It may provide for a stated period or until a stated event occurs, or maybe the latter of the two. So declarant control will exist until the latter of, and then maybe it gives a date certain, or the date that the last lot is sold, something along those lines. And again, finally, it may be tied to development period. Terms may be interchangeable. They may be one and the same. So again, look at your declaration. It's going to really give you some helpful guidance, because the Texas Property Code doesn't really do much. I'll talk in a minute about what one of the few things it does do, but overall, we don't get much guidance. Let's see. We've got question 1. Will this cover Chapter 82 of the Texas Property Code? This is really just for single family and townhome communities governed by Chapter 209 of the Texas Property Code. We actually have another presentation that delves into Chapter 82 declarant control. So I'm sorry that was not made clear enough. Another question: declarant turned over 4 years ago, kept one lot at the entrance, and the lot is empty. Is declarant just a homeowner and must follow the DCCRs and rules? or still under development membership. He falls under your sample provision. So really good question. And unfortunately, I'm going to give you an attorney answer. It depends. So you've really got to look at the declaration to see what kind of control the declarant / developer has retained by owning that one lot near the entrance of the community. So I recommend that you basically reach out to your general counsel. He or she should be able to guide you on that, because it really is going to take a look at your declaration and then rendering an opinion to get it done. It shouldn't be a big project, but it is something that you probably need to get a legal opinion on. Because the code doesn't give us clear guidance. All right. So here's one thing the declaration does do. It does provide for a mandatory election procedure in the event something happens. So these somethings happen. You have 120 days from the date that it happens to have an election where somebody other than declarant votes on the election of 1/3 of the board. So 1/3 of the board has to be made up of somebody other than or voted on other than the declarant. So somebody other than the declarant has to vote at that meeting. So what are these two somethings? Well, it's a two-part test. Part number one: if your declaration or your governing document somewhere set forth the number of lots that may be created and made subject to the provisions of the declaration. So we've got a lot certain somewhere in our declaration, maybe in our plats. There's other ways to do it, but somewhere there is a definite lot number. Well, then the rule is it's when you sell 75% of those lots to an owner other than another declarant or a builder. So if we've got 1,000 lots, the minute 750 lots have been sold to an owner who's going to reside there, not another declarant or another builder, then the clock starts ticking for the 120 days. So you've got 120 days to hold a meeting of members where the members other than the declarant elect a board member, and it's 1/3. So if we have 3 board members, one of the 3 would be elected at that meeting. So it's not a turnover; it's kind of a partial turnover, if that's what you want to use as for term of art. So that's option one, and that's if you've got a definitive number of lots. Option number 2, or scenario number 2, is if it's silent. If your declaration is completely silent as to the number of lots that can be created and made subject to the declaration, then it's the 10-year rule. So it is 10 years from the date that first declaration gets recorded. So after the 10 years elapse, again, that 120-day provision clicks in, and you've got to have that one out of the 1/3 of the board being elected by somebody other than the declarant. So that is the rule currently in place for 209 of the Texas Property Code. And it does not matter if the owner builds on the lot, just that the owner is not a builder. So very good question. And yes, so it's is the person who owns the lot in the business of building and selling, right? Building and selling over and over again. They are a builder. That is their profession. If that's not the case, if an owner buys the lot and the owner is building a house for himself or herself, is hiring a third party to do it, then that is an owner for the 75%. Now, keep in mind, we've had a few previous legislative sessions that have proposed changes to this section. One of the changes that was proposed was once 50% of the lots that can be made subject to the declaration is hit, then I believe, and I'm fairly confident this is how it was worded because I did a bill review on this at the last legislative session. but it's 1/3 gets elected. So 50% mark, 1/3 of a 3-person board. So 1 out of 3 gets put on the board, voted on by somebody other than the developer. When you hit the 75% mark, it's 2/3. So 2 out of the 3. So you would get control at 75%. Now, a lot of developers had concerns over this, right? Because they've got a huge investment in this community. And if this 75% gets hit, they technically lose power over the board, right? Because they don't no longer have the 2/3. Now they're only 1/3. And they were concerned that the board was going to be doing things that was going to affect the marketability of the community, affect their ability to build and sell lots, or build or sell lots to other builders, basically to finish out the community. And it was going to stagnate the process and prevent the community from being completed and allowing the developer to leave and move on to his or her next project. So that was their big concern, number one. And then number two, I was thinking through a lot of this, and there are ways around it, even if that rule became law. So it didn't make it far, but that was one of the concerns that developers had with that proposed legislative change. So the election I was talking about, it's at least 1/3 of the board members. It's the 120-day rule, and it's elected by owners other than declarant. And basically, once you're hitting that area, you've got to figure out what the terms of the board are, because that's when you're going to have a true kind of board. You're going to have an owner on the board. So it's smart to take a look at that. I've got another couple questions here. Outside of the normal list of items requiring a meeting during the development period, is the declarant obligated to hold an annual meeting if there are no elections? Would assume the governing documents would come to play, but wasn't sure if 209 superseded. Very good question, Miss James. And I'm going to get to that here in a second. So you'll get an answer to that one soon. From Patty, Patty Toms, do you anticipate any significant changes in the upcoming legislative session related to transition? Patty, always. I think that section that I just kind of spoke about, it is more than likely going to come back in the 2021 legislative session. So we will likely see it. But we'll see. We'll see how active that session is as it relates to POA, because right now I imagine a lot of the legislators are looking at COVID-19, looking at those states who have yearly legislative sessions, seeing how they're coping with all of the legal issues that COVID-19 has brought up. So they very likely could be focusing more on that and less on some of their normal things that they focus on. So it really is up in the air right now, Patty, because as you know, Texas is every other year, or odd numbered years for legislative session. So ours is coming into full swing starting in 2021. But a good question. Another question from Jessica Ramirez. Hi, Jessica. The developer builder has control, although it's time for him to transition to the owners as they have sold out. If the developer builder does not file the bylaws and is provided a non-filed version, can the meeting occur and the new board file the bylaws? So Jessica, I think it is very possible. Number one, for that to occur, you've got to look at the governing documents. But I will say, Chapter 209 of the Texas Property Code provides for a way to kind of force an annual meeting. So, do your best to work with the developer to get them to get all their ducks in a row so that the association can properly hold the annual meeting. But if it really is not going to happen, then reach out to your general counsel. He or she should be able to help guide you so that you can have a successful first meeting and basically get the control over to your owners. But very, very good question. Classes of membership, are they necessary? Question mark. Well, I don't know. Some developers really like them and we see them, other developers don't, and they go about it a different way. We're seeing more and more declarations nowadays that do not define class. It's pretty much one class of membership. and the developer or declarant just has control until a date certain, and they get to control elections, they get to control decisions, amendments, all that good stuff until that 75% or 10-year mark comes into play, and then 1/3 kind of gets kicked in. So many developers now are including that statutory provision in their governing documents. All right, board meetings. Going back to Lisa James's question, Lisa, you must have just been. Have you seen these slides before, Lisa? You're anticipating where we're going with this. Board meetings. Okay. Does a developer have to have them? So let's talk a little bit about what they are. So they are deliberation between a quorum of the voting board during which association business is discussed, and here's the board takes formal action. So if the board, and again, this is more under control than I'm thinking of, if the board is just getting together and is basically having more of a work session where they look at the issue, they kind of tackle whatever it is, they come up with ideas, but they do not decision make. So no decision making is occurring. That is technically not a board meeting. Rather, it is a work session. So what does that mean? Well, the general rule of thumb, and it's 209.0051 of the Texas Property Code, the general rule of thumb is that for all meetings of the board where you're going to be discussing and taking action, you must provide notice to your ownership. And 72 hours is the requirement. There's some other things that I'm not going to get into, but you do have to provide notice to your owners for all general and special meetings of the board. So what does that mean for the developer? Does the developer have to comply with that every time they want to adopt or amend a governing document? The answer is maybe. So the code goes on to say that you do not have to have board meetings during the development period, and you don't have to provide for this notice unless, and then here's the ... There are 4 items. Unless you are adopting or amending a governing document or a dedicatory instrument. Number 1. Number 2, increasing assessments or adopting or increasing a special assessment. Number 3, electing non-developer board members or establishing a process for electing them. And then number 4, changing the voting rights of members. So those are the 4 things when you're probably going to need a board meeting, the developer is. So then the next question is, what about amending the declaration? What about amending the declaration? Or maybe it's worded so that any governing document. So what if the declaration is worded such that it provides that the developer at any time can amend the declaration or annex additional property by filing an annexation document without any kind of board involvement, without any kind of board vote? The declarant can just do it. They don't need board action. Do you have to comply with 209.0051 to adopt that amendment to the declaration? Technically, no. Why? Because there is no board action requirement. And so because board action is not required, the developer or declarant can just do it without a board meeting. So there is no open meeting requirement in that particular instance. Now, a question arises, let's say you're 70% on in terms of build out and you want to do a big change to your declaration. Is it a good idea, belt and suspenders, maybe you have a properly noticed board meeting? Yeah, I don't think it is a bad idea, but technically, is it required if the declaration is worded appropriately? The answer is no when reading the statute. I've got a question from James Arthur. Mr. Arthur writes, does the recorded legal description provide the declaration a set of lot totals versus a specific number listed in the declarations? So what if the legal description provides lot totals rather than the declaration? Well, I think the legal description of the capital P property is attached as an exhibit, which means it is part of the declaration. So James, I think that would satisfy the rule that the declaration state a number, because that exhibit is part of the declaration. So I think you could probably hang your hat on the 75% rule. But again, of course, James, I'm not your attorney. I haven't, or maybe we are, but I have not issued an opinion on that issue. But that's kind of what it sounds like to me. Another question from Denise Jimenez. Hi, Denise. I hope you've been well. What if the developer board is voting on fines or referring a delinquent file to legal? So if you are still within that development period, you do not technically have to have a board meeting to do it, because those requirements apply to non-developer communities. The only things that apply to developer communities are those 4 items that we just went over. But very good question, Denise. A question from Brian Schroeder. Special rules for passing builder projects. Open meeting required. Passing builder budgets. Brian, that's an interesting question. Unfortunately, I've got to give you the attorney answer. Maybe, maybe not. I'd really, that's definitely an issue for your counsel to kind of look at and give advice on, to see whether or not that section of 209.0051 comes into play. Sorry, I couldn't answer that one for you, Brian. All right, let's get back to our slides here. Contracts. So this general provision, so I'm going to go with general rule, and then I'm going to do exception for developer. The general rule of thumb is an association cannot enter into a contract with somebody, a board member or somebody related to a board member within the 3rd degree of consanguinity or affinity. So basically related to a board member by blood or by marriage, and then there's different degrees, but we won't get into details on degrees of consanguinity or affinity. They cannot do it. The association cannot enter into that contract with that board member or somebody related to that board member unless certain requirements are followed, and you have to follow them to the letter. You basically have to Chinese wall the person so that they can't really interact. You have to get other bids. You cannot allow the owner to be or the board member to be involved in the voting process whatsoever. You've got to give notice to your owners at the meeting of what you're doing. You've got to have it written, a laundry list of things. And look, generally, my recommendation to boards that wish to enter into a contract with a board member or somebody related thereto is to avoid it. Why? Because there is an appearance of impropriety. So even though it is legal to enter into that contract directly with them, those who have the financial stake in the company, as long as you follow these rules, we just tend not to recommend it, because there's no need to potentially stir the pot. I mean, I'll give an example. I've got a board who did that 3 years ago. It was probably a $70,000 pool contract. It was like a replaster or something along those lines. And the board decided to enter into the contract with a board member. They followed the procedures, but the owners made a big stink about it, and it forced them to spend money on me to kind of deal with the social media backlash, attending board meetings, all that kind of stuff. So unless the board member is doing it for cost, they're not making any money. And I mean, these savings is astronomical, but this board member still be willing to provide for all the contract protections and insurance safeguards, then it's probably just a good idea to avoid it. So that's the general rule. What about developers? Does this apply during the development period? And the answer is no, it does not. It does not apply to a contract entered into by a POA during the development period. So as long as there's a development period, you are good to go. What happens if there is no stated term for the development period? So it's not referenced in your declaration at all. You've got to look at the document. You've got to try to figure out whether or not declarant control means development period. But if you're unsure, head scratcher, safest advice is to do what? To comply with the code and follow all those rules if you do want to allow for a contract directly with the developer, who is also a board member, right? May the contract continue after the development period expires? Yes, for Chapter 209 in townhome communities. As it relates to condominiums, there's actually some rules in Chapter 82 that gives a little wiggle room for the association as long as they take action within a certain period of time from declarant control turnover. But again, as I mentioned earlier, we're focusing more on single family homes and townhomes that are bound by Chapter 209 of the Texas Property Code. All right, got some questions coming in. Oh, do not read out loud. I won't even mention your name. Steve Roebuck. Steve, afternoon, sir. If a vendor is contracted and later becomes a board member spouse, what do you recommend as far as disclosure? Geez, Steve, sounds like this may not be a hypothetical. Sounds like you may have had to deal with this in the past. You know, belt and suspenders, but technically you've already entered into the contract. So do you have to comply? Maybe not. But should you follow at least some disclosure requirements and put it in the meeting minutes? Yeah, again, I am all about belt and suspenders, giving some information to your owners. So that's probably a good idea to do. But very, very good question, sir. All right, next question. Section 209.0051B, as in boy, a board member is ineligible to serve on the board if you receive written, documented evidence from a database or other recorded record maintained by a government law enforcement agency that somebody has been convicted of a felony or crime of moral turpitude within the last 20 years. So, felony or crime of moral turpitude conviction within 20-year period. There is no exception in the code for directors appointed by the declarant. There's also a new law that came into effect in 2019 regarding cohabitation by spouses. And, you know, in a nutshell, it basically says if you are cohabitating with your spouse, so same roof, you both can't serve on the board. It generates an exception for declarant or development period. So developers really don't have to worry about that one. But the felony or crime of moral turpitude does not have an exception. So it does apply. Keep that in mind. All right, so again, let's go back to kind of summarization. Remember, the Texas Property Code references 2 periods. It references and defines the development period. It references, but doesn't do a great job defining declarant period. To be honest, both periods aren't really defined well. What does that mean for you as a manager? It means that you really have to dig into your documents, get your counsel to dig into the documents so that y'all can understand what the periods are, what each one means, and when they terminate, so that you know when owner control will kick into gear. Board meetings and contracts are based on the development period, but appointment and election of directors are based on declarant control. That is the general rule of thumb. Of course, your declaration could provide something completely different. So we are at a little after 2:10. We still have some time left. So we can move into some Q&A. All right, we've got a question. Understanding the board meeting requirements pertaining to annual meetings of the members. So it is a member meeting, not a board meeting. A resident questioned the requirement for an annual meeting for a community less than 2 years old. Declarant planned to have a town hall this year, ... But of course, what happened? COVID-19. So is there some sort of annual meeting requirement? The answer is yes. Generally, you should have an annual meeting. Again, there really is no election taking place, so there really is no formal action. So it's more like a town hall. But both your bylaws many times, and then Chapter 22 of the Texas Business Organizations Code talks about annual meeting requirements. So what to do, what to do. Why not just have a virtual meeting? Those are fairly easy. And from what I understand, you can get a Zoom subscription for anywhere from $15 to $20. So it's very cheap. Have your virtual annual meeting or town hall, whatever you want to call it, so that you're complying with your bylaws and or Chapter 22 of the Texas Business Organizations Code. COVID-19 shouldn't prevent it. And luckily enough, 209.002 of the Texas Business Organizations Code was amended in 2019 to specifically allow for virtual member meetings. If you're unsure of this law change or a bit of a head scratcher, our law firm's website, you can take a peek. We've got an education series that talks specifically about virtual meetings, so that can help y'all navigate. Next question from Sarah Marie Blunt. Miss Blunt, what does belt and suspenders mean? Oh, sorry, Sarah Marie. I didn't read that. I wasn't supposed to read that out. What does belt and suspenders mean? It basically means, so it's, Sarah Marie, I'm not going to describe it. It's protecting yourself, adding as many layers of protection as you can so that you have great arguments to make if somebody tries to challenge some sort of action. So not only are we right because of X, but we're also right because of Y. So it's just a good way to add an extra layer of protection. Attorneys like as many layers of protection as we can get you, so that you've got multiple arguments you can make that you're right, the other person is wrong. Is the declarant obligated to allow legal consultation? That's a good question, and I really, at some point in time, I think at the very least when that 75% is hit, I think there needs to be a general counsel involved advising the board. So it's a really good question. Working with the developer and the developer's counsel is hopefully going to help, because attorneys are held to a higher standard of care, and we've got an obligation. Depending on who the attorney represents, the attorney may have an obligation to the association if they represent the association. Another question from Ms. Ramirez. Is there anything that talks about if another relative lives in the same community and is on the board, have a dad and father on board, and they team up on decisions? I think it talks about cohabitation of two people. So if they're under the same roof, I think you may be able to do something, Jessica, but if they have two different lots, then no, nothing you can really do about it. Where would one look for state laws regarding transition of control of condominium associations? Very good question. It is Chapter 82 of the Texas Property Code. As I mentioned, we will have another PowerPoint and discussing Chapter 82 turnovers, because I've gotten a few comments on that. Okay, can a board require members to wear a mask to attend an in-person meeting and refuse attendance if they choose not to wear one? Oh man, I don't recommend you have a member meeting in the first place because of questions like this, right? What do you do? Do you have a law enforcement and an off-duty police officer there that maybe enforces the mask requirement? I think that's a good idea. A lot of y'all have seen social media postings where when somebody tries to approach somebody else about, you've got to wear a mask per state order, they get crazy. And so sometimes they're recommending that you don't approach them, but rather report them. There are penalties associated with not following state mandates, but it's a difficult question. So if you are wanting to go down that in-person member meeting route, definitely get your counsel involved so that he or she can help you navigate the right things to do and address questions that you just asked, because that's a very good one. Clarify my understanding of the third member rule within 120 days, which I thought existed regardless of declarant developer period, that forced the addition of a member added to the board for 1/3. So it is a rule and it must apply, but there's two rules that can apply. So if the declaration talks about the total number of lots that can be made subject to the declaration, then it's the 75% rule. So once those 75% of the lots are sold to somebody other than, are sold to an owner other than a builder or another declarant, then 75% triggers. 1/3 of the board has to be elected by somebody other than declarant, which means it's probably going to be a resident who's on the board. That's part one. Now, number two, if the declaration is silent, then it is the 10-year rule default. So 10 years from the date the declaration is recorded, after that 10 hits, that's when the third comes into play. So those are the two rules. If the developer meets in person to host a virtual annual meeting, do they have to offer the membership the option to meet in person as well? So it's not really an in-person meeting then, right? The developer may just be getting together with the manager to host the in-person or to host the virtual meeting. So in that instance, you're okay. I mean, it really isn't an in-person meeting, right? It's more of a two personnel getting together to host a virtual meeting. Developer contributions, how do you make a case for one? Developer's new section should not be a monetary detriment to the community, ... Right? Very good question. Give attorney answer. It depends. It's all about how your governing documents are worded. Do your best to work with your counsel to try to seek some sort of resolution so that the developer is willing to deficit fund the association. So deficit funding is kind of like you've got a budget for $100,000, but because the assessment is low, you're only budgeted to collect 80, so you've got a $20,000 deficit there. The developer, many times will contribute that 20 because they've got a marketability structure for assessment levels. When is it acceptable for a declarant to turn over reserves and property taxes to the association? Again, another good question. It really depends on how your governing documents are worded. Sorry, another attorney answer. I can't give you a straight answer because the code doesn't give us much in the way of guidance. You mentioned that a developer can keep control of ACC for new homes, but what about modifications? Good question. Again, it depends on how the documents are worded, but I'm seeing more and more documents worded such that the modification part of what an ACC normally does is given over to the owner's board of directors at some point in time, and it's just the new construction that the developer holds on to. Zoom meetings have not helped with quorum due to COVID. Proxies have not been picked up by the board. Some communities have had 6 meetings. Geez. Jessica, that's horrible. Are they doing online voting or are they just doing voting via absentee ballot? Because I will say in years past, prior to this, online voting has allowed me to meet quorum. So if they haven't had online voting, well, then they need to consider spending the money. I know online voting can be expensive. There are multiple options out there. I'm aware of 3, text to vote, Vote HOA Now, and then associationvote.com. Those are options. So get bids and tell the board, look, if you want to meet quorum, you've got to do it this way. Now, if you've had 6 meetings already and they've all failed, speak with your counsel. There may be a way to kind of pump the brakes a little bit and wait for 2021. If the document states the first annual meeting must be held within 90 days of incorporation, however, there are no homeowners yet. When do they have the first annual meeting? Well, darn. Maybe you should amend the documents to give a little bit more flexibility on when you have the first meeting. If not, just have the meeting, right? Follow corporate formality. The members of the association are who? The developer. If you haven't sold any lots yet, the developer is the member of the association. So it's okay to have that type of meeting. You're meeting your governing document requirements, you're following corporate formality, and that is okay. All right. What if you have a declaration that defines the number of lots in just one phase, but the association has multiple phases? Well, geez, I don't know. Maybe you have to follow the 10-year rule. It's a good, very, very good question, Ms. Washburn. Another question. Developer gave sections to the HOA without notifying the HOA and did not sod the areas. Good question. So for conveying property, there's two parties to every transaction, right? The grantor, the one who gives the property, and the grantee, the one who accepts the property. So if the association didn't accept the deed, was there really a transfer? Good question. Maybe not, maybe so. Speak with general counsel because it really is going to depend on your governing documents as well. So very good question. The answer is maybe you can fight back on it. They have tried everything, including online voting. Well, darn it. Then yes, there may be some options for you to wait until next year to have your annual meeting. All right, going back again to the election process at 75%, the declarant still has its voting total rights, i.e. Class B equals 10 votes versus Class A when counting voting totals, ? So remember, the declarant doesn't get to vote at that election. So once that 1/3 election is being held, declarant has to stay out of it, right? They don't get to cast their votes, their declarant votes. If the board would like to amend the CCRs, can they still use the developer to amend the docs if the associate has been turned over to the board? However, the developer still owns a significant portion of the lots. Very good question, Ms. Bracken. The answer is more than likely, if there's still control and the developer still has control and power to amend, we very well may be able to use it to do it. There is a section of 209 you have to navigate for that. But again, your general counsel is going to be able to give you a good legal opinion on that option. But Brandy, to answer your question, yes, there may be an option to get it done. All right. Can COVID be used as an excuse not to have an annual meeting as someone to wait till next year? How long can the COVID excuse be used? It depends, right? I've got some communities that allow for flexibility in when to hold your annual meeting, and I'm okay with considering wait until first quarter of 2021. I've got other communities that have a date certain requirement for the annual meeting. And in those instances, you really need to consider the virtual option and online voting. If, however, you've tried and you've failed repeatedly to meet quorum, what if you amend your bylaws to provide for some sort of quorum reduction procedure to allow for an election of the board to be held? That's an option. That's an idea. And actually, 209 of the Texas Property Code allows for the board to amend the bylaws to provide for something like that. So get with your counsel. Maybe that's how you accomplish your goal of having a board and having an annual meeting. So I played the general counsel card, and one of the responses was, "You are my general counsel." Well, okay. Send me an email, and I'm happy to take a look and give you an opinion. All right. Any other questions? Well, y'all get out of school early. You don't have to listen to me yap for another 7 minutes. I hope today was informative and gave you a little bit of info. And as always, if you ever have any questions, it doesn't mean you can't call me. I'm always happy to listen and have a 5-minute freebie, 5-minute phone call with you. But just remember, similar to today's phone call in education, you get what you pay for, right? So keep that in mind. All right. Well, y'all enjoy the rest of your day and be safe this Halloween season if y'all celebrate with kiddos or just amongst yourselves. Bye, everybody.